Owen Tyler here. I just want to thank you all for dialing in today so that we could have a broker in charge conversation about the state of the corona pandemic in South Carolina, what we're working on at the state level, what some of the things we're hearing at the local level are, and how things are unraveling at the federal level. Today, we have with us Lindsay Jackson, our chief lobbyist, Byron King and Austin Smallwood, our dynamic legal duo, and Nick Kremydas, CEO of the Association of Realtors. So Byron, why don't you start us off with an antitrust statement? Sorry, one other thing. Before I start, everyone is in listen only mode. Hopefully we'll have a little bit of time at the end so that you can chat in a question, and we'll try to answer questions kind of as they come through with that. So without delaying anymore, Byron, a little antitrust statement for us, please.
Yes, sir. Thank you, President Owen. Thank you for attending today. I am one of the 3 attorneys at South Carolina Association of Realtors. This is an antitrust alert to make sure that we don't violate any antitrust laws while we're on this call. We're an association of competing brokerages, so business models, pricing, business operations. While we can discuss those, we have to be careful that everybody's free to make their own individual business decisions. There's no antitrust colluding, no antitrust deciding to boycott another business model. Thank you, Mr. President.
Sorry, I had muted myself. Thank you, Byron. Now we're going to start with Lindsay Jackson. Lindsay, I believe you have a legislative update for us. Nick, sorry.
I'm going to throw up just a quick poll to have everybody sign off on the agreement not to violate antitrust calls on today's call. Is that working?
I see it. Yes.
There it is. So if the attendees could click yes or no that they agree not to violate antitrust today, I would appreciate it. We'll give this a few more seconds. About 80, we got 83, 84% have voted. So if you haven't voted, you're going to have to log off the call. This is a test of your participation and your agreement not to violate antitrust. So I'm hoping this will be 100% in favor of not violating antitrust. Mr. President, let's see, we will close the poll, and we have, as of right now, this is the largest webinar we've ever hosted, Owen. We've got 548 brokers that are participating, and that number continues to eke up. We just hit 550. Thank you all for participating today, and with that, I'll turn it back over to Owen. Thank you.
Wonderful, and I'll turn it over to Lindsay.
All right, just making sure my mic's on. I hope everyone can hear me okay, and I hope y'all are all doing well, given everything that's going on. Just wanted to start out and give kind of a brief federal update on what we're seeing with the stimulus and relief packages that are happening in Congress. In just a few weeks, the White House has literally gone from proposing a few $1 billion in relief to one of the largest stimulus packages that we've seen in recent history. Just going to kind of break down each of these 3 phases of the stimulus package and kind of update you on what's going on right now in DC. So the first phase, in late February, President Trump asked Congress to provide about $2.5 billion to fight the spread of the virus. But after negotiations with Congress, they settled on about $8 billion. This part of the relief effort was passed on March the 6th, and it essentially provides funding for the CDC, the FDA, the National Institutes of Health, and the Small Business Administration. It provided $4 billion to make more coronavirus tests available and about $1 billion in loan subsidies for small businesses. So phase 1 really provided mostly support for businesses, but not necessarily independent contractors. So kind of moving on to phase two, this package was negotiated by the Treasury Secretary and House Speaker Nancy Pelosi. It was signed into law by Trump, I believe, Wednesday of last week. And it's really unclear as to how much this is actually going to cost. The estimate we've seen is about $100 billion, but this phase would provide free coronavirus testing for the uninsured, 2 weeks of paid sick and family leave, increased federal funds for Medicaid and food security programs like SNAP, and increased unemployment insurance benefits. So as phase two was being passed by the Senate, phase three was kind of still in the works, and it's still being negotiated at this point. The Treasury Department released about $1 trillion relief proposal that included more industry-specific bailouts and payments to individual taxpayers that I'm sure you all have been hearing about on the news. And this phase would essentially provide 2 rounds of direct payments to taxpayers. This is the $1,200 check to individuals that y'all are probably hearing about on April the 6th, and I believe they have one scheduled for May the 18th. The amounts have kind of gone back and forth, and this is loosely going to be based on income level and family size. There's about $3 billion in small business loans, so employers with 500 employees or fewer would be eligible. A $50 billion bailout for the airline industry, and about $150 billion for other industries that are affected by the virus, including hotels, casinos, cruise lines, stuff like that. Phase three is still in the works, and unfortunately, with anything political, there's a lot of behind-the-scenes politics going on. So the House actually came out with their own bill yesterday, which included a lot of items that were not necessarily related to coronavirus relief, but rather some more kind of long-term agenda items. But in my discussions with NAR staff right now who are working with Congress, the Senate is working towards a deal. And it looks like if they strike a deal, House Speaker Pelosi will go along with the Senate version. And this is essentially trying to make sure that Congress is weighing big business versus small business, with the ultimate goal that they get some liquidity back into the market as soon as possible. So that's kind of the federal side in a nutshell right now. Just wanted to give y'all also a quick update on what's happening in the state. South Carolina's legislative session is stalled right now. No announcements as to when they're going to return, though they'll probably have to return sooner rather than later so they can pass a continuing resolution to make sure that state government is funded at the current levels that it is right now. And as we have that information, we'll be sure to keep everyone posted. The governor has held multiple press conferences over the past few weeks to give us the latest CDC information, and DHEC has been providing everyone with the numbers on the confirmed cases in the state. We're not hearing a lot of chatter right now about shelter-in-place orders. It's not on the table as of right now, but things are pretty quickly evolving, so it's not out of the realm of possibility, especially since DHEC has projected that the numbers of confirmed cases are going to grow exponentially this week, and we saw that a little bit yesterday with I think 120 cases from the day before that. So jumping into kind of what SCR has been doing, working with the governor's office and our elected officials, we're making sure that, trying to make sure that real estate is deemed as an essential service. SCR has been working with the Association of Counties kind of from the get-go to make sure that we're monitoring local government closures and ensuring that necessary real estate operations are deemed essential in the case of a complete shutdown. Closing a transaction requires a lot of different interactions with county and municipal governments for different services like property inspections or tax payments or deed recordings. We're continuing to advocate for these types of services to be defined as essential. Each government office is operating under their own policies right now, and many counties have actually shut down their offices to the public and have passed emergency ordinances outlining and defining what their essential services are. So we have been in close contact with each of our local associations and asked them to help us contact their county administrators and their county councils to make sure that as these ordinances are getting passed, that real estate services are included and are deemed essential. So we've gotten a lot of good feedback from the local governments on this. This was sent out to all of our local government affairs directors and local association executives. The local governments were very responsive in most places, and they appreciated the guidance from SCR and We have not gotten word so far that we have not gotten word that any of the ROD offices have closed completely, but we are continuing to monitor the situation as we go forward. Also, SCR has been in very close contact with the governor's office and has officially requested that real estate be defined as an essential service in any upcoming emergency or executive orders. So essentially, this would allow for the continued access to local deed recording offices and other offices or services that are related to real estate operations. SCR has been in regular contact with other trade groups like the Chamber of Commerce, the South Carolina Bar Association, the Home Builders Association, the Palmetto Land Title Association, and others to make sure that our governor, our elected officials, and all of our decision makers know how critical it is that to our economy that our auditors and our recorders and our treasurers and courthouses remain accessible, even if it's on a limited basis. We're making sure that we communicate this to the governor's office and others, because there are so many different industries that rely on county offices to be able to transact their business. And a total shutdown of these services would really be devastating to the long-term economy. Luckily, Governor McMaster understands real estate, knows real estate very well, so he knows the importance of keeping these services going. We've gotten a lot of good feedback from his office regarding this matter, and we'll continue to be in contact with his office going forward, looking at any executive orders that he might put out and what would be included in those. So we'll certainly keep you posted as we know more on that. And then kind of jumping into another issue that we've kind of seen pop up across the country, state and federally right now, electronic notary. So right now in South Carolina, we don't permit electronic or remote notarization. We do have a bill that passed the Senate last year, but it's hung up in House Judiciary right now. We had a hearing on it earlier in the session, but it unfortunately got stuck behind a pretty lengthy agenda in the committee earlier this year. So we've been working with the mortgage bankers, the Bankers Association, the Palmetto Land Title Association, the Bar Association, and Secretary of State to kind of work towards the passage of this bill. But since the legislature is not meeting right now in regular session, we're kind of exploring some other options. There are currently about 23 states that allow for electronic or remote notaries, but kind of given everything that's going on, there's been a push for Congress to immediately allow for transactions to be completed using remote notary. So federally, there's legislation pending right now. A Senate bill was introduced last week, and a companion bill in the House was dropped yesterday. NAR is working with both sides and urging Congress to include it in the stimulus package. In my conversations with NAR staff this morning, they're hearing that it could be included in phase 3 of the relief package that they're working on right now, but it's more likely going to be attached to phase 4 or 5, which NAR is thinking is going to be a little bit more industry specific. So we'll keep you posted as we hear more about that. But essentially what the bill would do was it would permit nationwide use of remote notarization with standards for consumer protection, and it would provide certainty for the interstate recognition of remote notarization. NAR has been working with various trade groups, urging Congress to make all the efforts to keep these systems up and operational, to make sure to prevent transactions from being canceled, delayed, or interrupted during this time. So kind of how would this work? So pretty much in the same way that many of us are working remotely right now, this legislation would allow a notary and a signer who are in different physical locations to execute electronic documents using audiovisual communication. So this would facilitate continued transactions and would prevent at least some of the market disruption that is most likely going to occur. What are states doing right now? So as we mentioned, there are 23 states that currently have remote notary in place, but a few states like New York, Colorado, and Connecticut have addressed this issue by executive order through their governors. So New York specifically and Colorado and Connecticut look pretty similar, but there are certain requirements that have to be met. pretty much the person that's seeking the notary services, if not known personally to the notary, they have to present their valid photo ID during the video conference. They can't submit it before or after. The conference must allow for the direct interaction between the notary and the person, so there can't be any pre-recorded videos of the person signing. It has to be in real time. The person must represent that he or she is physically situated in the state, and the person has to transmit by fax or email a copy of the document to the notary on the same date it was signed, and then the notary has to transmit the copy of the document back to the person on the same day as well. So we've been working with the governor's office and the Secretary of State on this to relay the need that we will need remote notarization in the coming days. And we've also have a few legislators who have gotten involved and are expressing their support to kind of move this effort forward. So we will continue to work with NAR kind of on the federal side to see what is going to get done there, and then continue to work within the state with the governor and our legislators to see what we can do moving forward on this. So that's kind of where we are right now. Like I said, things are changing by the minute, it seems sometimes. So stay tuned for any updates we have coming out. And I will go ahead and turn it over to Austin to update everyone on contracts.
Hey, before Austin gets started, let me jump in real quick. Thank you, Lindsay. I've been answering quite a few questions. There is a question area in your GoToWebinar control panel. Feel free to ask a question. If you have a question, I will make the answer and question available to the entire group, unless you want to ask it privately, and I can respond to an individual privately. We have 691 people on the webinar today. That's pretty amazing. Thank you all again for participating. Austin, back over to you. Oh, and if you want to follow along on the agenda, we've got some handouts attached again in your control panel. There is an agenda that you can follow, and we'll be covering some of the questions are kind of jumping ahead of the presenters. So thanks for your patience, and Austin, I'll turn it back over to you.
Thank you, Nick. Going to go over quickly couple things that are in your contract that will be especially helpful to you given the current situation. The first thing is that there are a number of deadlines in your contract. There's deadlines when it comes to closing date, earnest money, financing, and repairs. Be aware, obviously, with the uncertainty that we're having, that you should try to make those deadlines longer than usual. So if you previously had a deadline where you only gave 10 days for something, maybe now you want to give 15, want to give 20. You can always beat a deadline, but you're sort of in trouble if you are not able to meet the deadline. Several of these provisions in the contract essentially waive your client's right to ask for things once they miss a deadline. So anticipate that there could be delays. Make sure that you're adding more time than you would think you need. If you always add more time than you think you need, and if you don't need it, then you don't have to take it, but at least it's there if you need it. Especially when it comes to closings, probably realize that that it's going to be much harder to maybe do a 30-day close given the situation. So go ahead and give yourself 40, 45 days. If you're able to close in 30, that's fine. You can still come ahead of the deadline. But if you need more time, then you've already got it sort of built in. The next thing that I would recommend is, especially if you have a buyer or a seller client who's got some uncertainty right now and is kind of nervous about situations, then the due diligence option is going to be a great tool for them. That will, of course, allow a buyer to walk for any and all reasons, but it also does not obligate the seller to fix anything unless it's negotiated for. So if you have a seller who's nervous about maybe making a lot of repairs because of economic uncertainty, things of that sort, then that kind of gives them some flexibility. It also gives the buyer some flexibility, and that they can kind of see how things are going and whether or not they want to be able to get out or not. The important thing with due diligence is it's not a buyer-friendly or a seller-friendly option. There's essentially, you got to think of it as like a seesaw. There's two levers on it. The key is to try to make those as equal as possible. So the buyer is going to want the buyer is going to ask for so many days for a due diligence period, and the best way to counterbalance that is with that termination fee. So if the buyer wants more time due to this situation, maybe as a representing a seller, if that's something you're entertaining, then maybe you ask for a little bit more of a termination fee than you normally would to compensate the seller for those additional days in due diligence. The last thing I want to kind of point out is regards to earnest money. So that is the number one call we always get on the hotline, especially given the time now where parties are going to be maybe having more discussions, maybe looking to get out from a contract. Earnest money discussions are going to be even more important. I do want to remind everybody that the courts in the state are essentially closed until May 1st. So you probably already knew what the backlog in your county at the magistrate and the circuit court level was prior to this. You're now going to add on to that about a month and a half of no activity in the courts. So you're going to be super backed up that. So we've just been telling parties, hey, you guys can either negotiate things now, or you can wait, 4, 5, 6, 8 months, maybe a year down the road. And the first thing the magistrate or the judge is going to ask you is, what efforts did you take to try to resolve this conflict? And if you wait 6 months to fight over earnest money and have never had the discussion, the judge is probably not going to look at that kindly. Keeping in mind with that, the only comment I will make on how much should earnest money be is that once you hit $7,500, you are no longer in magistrate court, or you are now in circuit court. So again, with no circuit court cases happening until May 1st, there's going to be a massive backlog of car wreck cases, medical malpractice, workers' comp issues, and even criminal cases. So you're really going to want to try to not be into the circuit court area if you don't have to be. A couple other things that if you have clients that are very nervous about earnest money, there's a couple of things I would recommend. You can always have a law firm hold the funds. That does give your buyer and seller a little bit more flexibility because they are not subject to your license law. Just make sure that there is an escrow agreement signed by all parties. That escrow agreement will be something signed by the law firm, the buyer, and the seller, and will dictate the terms under which the money can be dispersed. If it's held in a brokerage account, you guys are limited by mutual agreement parties or a court order. So 2 things that I would look at would be, when you're negotiating earnest money, don't have, tell the parties, hey, it may be a while before we could possibly get this. So let's make sure, keep that in mind when you're putting what your amount of earnest money will be. Also, if we do the due diligence option, maybe we consider having the due diligence money, the earnest money due after the due diligence period. That way, if the parties terminate under due diligence, you don't have any earnest money to fight over, and it's a much cleaner exit. But obviously, the best thing that you guys can do, as we want deals to close, is to remember Article 1. So that says that you guys have to be honest with all parties, but you still have to promote the best interest of your client. It's gonna be more important than ever now that you actually have those broker-to-broker conversations. And I have encourage your agents to talk to their parties, talk to their agent, but sometimes it may be a case where the brokers need to get involved. Try to salvage these deals, try to work out, try to give a little bit, understanding that there's a lot more flexibility is going to be needed. And hey, maybe if we can, the person needs an extra 10 days. That's not the end of the world. Let's go ahead and try to negotiate that stuff. So the next thing we wanted to cover.
Austin, can I interrupt you real quick? Can you repeat the one section about what you just said about earnest money and due diligence?
Yeah, absolutely. So if you look in paragraph 5 of your contract, earnest money has 2 options. You can either pay it you can either present the earnest money with the contract, or you can present it at a later date. And then also your due diligence has an end date. What I would do if you're worried about it is, say the due diligence period was going to end on, March 30th. I wouldn't have the earnest money due till April 1st. That way, if the contract is canceled under due diligence before May 30th or March 30th, you don't ever have to worry about earnest money and have an earnest money dispute because the earnest money was never delivered. So that is one way that you can sort of get a much cleaner, quicker exit.
So
once you receive the money, you have to deposit it. So you can't say, well, hey, the contract says April 1st, but you received the money today. So once you receive the money, you have to put in the account till within 48 hours. But if you tell your client, hey, do not send me an earnest money check, do not wire me earnest money funds until after until the due diligence period is over, that's going to be an option for you.
And Austin, can you explain why we don't have a separate form for escrow agreements?
Yeah, so escrow agreement, the reason we don't have that form is because that's going to be something that's dictated by the law firm, because the law firm is going to be the one that decides what they do. certain law firms like brokerage firms have different levels of risk tolerance that they're willing to take, and what they, under what conditions will they disperse funds. And so the agreement is really, and I've never seen an escrow agreement that requires a staple. These aren't very complicated documents. If the law firm that you are using does not have one of these, require it. Make sure that there's 5 copies made, one for the law firm, one for the buyer, one for the seller, one for the buyer's broker, and one for the seller's broker. And make sure it essentially all the agreement states is, the law firm holds X amount of earnest money for buyer and seller and will release under the following conditions: 1, 2, 3, 4, and then all parties sign it. Because these are such unique documents and they're actually something from the law firm, that's why there's not an SCR escrow agreement.
All right, thank you.
Okay, so the next thing we've been getting a lot on the hotline are questions about various addendums to address the coronavirus. And hey, I saw this form from this particular state or this other state, and whether or not we should use those on our contract. So the way I always kind of advise on addendums with our contract is you got to think of the SCR contract as like a Ford or a Chevy. And you wouldn't put Ford or Chevy, or you wouldn't put Chevy parts into a Ford because it doesn't work. The contract is supposed to work together. So our contract is meant to work with our addendums. If you insert a different addendum into our contract, the issues there could be directly conflicting language that you're not aware of. It could use definitions that are not in our contract. And the most important thing here is that actually can be considered the unauthorized practice of law, because you are taking a form that was not created by SCR counsel, that was not drafted by a lawyer in South Carolina, and assuming that whatever the law is in Ohio, Pennsylvania, Georgia is directly relatable to the law in South Carolina. Reminder that the unauthorized practice of law in the state of South Carolina is a felony. It is also a violation of the Code of Ethics. So do not do it. If you find a form on there on the website, do not, if your client absolutely insists on an addendum, then they need to go to their attorney and they need to have a South Carolina attorney draft an addendum. But hopefully you can kind of explain to them the options that we mentioned in the contract and show that the addendum may not be necessary, and it may open up a more can of worms than you were hoping to do so. But I really caution you against, please do not use a form that you find on the website, on a website on the internet that someone sends you, because while you feel like you may be trying to fix a problem, you are actually going to probably create a bigger problem than you started with. The next thing I want to kind of get to is some open house guidance. So NAR put out a list of guidance that they will give regarding open houses. I'm going to kind of just give a brief summary on that. The most important thing to do regarding open houses is have a talk with your clients. Feel free to be open with them. Talk to them and say, hey, are you sure you want to do an open house during this time period? Understand that your requirement to promote the best interest of your client does not mean that you have to put your health and safety at risk. If you are not comfortable holding an open house due to the virus, be open with your client about it. But if you have that, but I will caution, if that is your feeling, you need to have that as consistent advice or consistent feeling to every client that you have. If you do not want to hold open houses, you need to not hold open houses for anybody. But have a conversation with them. Say, hey, do we want to ask people if they've traveled before doing an open house? Do we want to put in extra cleaning procedures? Do we want to have hand sanitizer at the door? Do we want to have extra Clorox wipes? Have a conversation with the client. Understand that these are difficult times, but this is when really having every party be aware of what they're thinking, feeling is important. Don't just assume that someone is happy with you having an open house, or that they of course don't want to have it. Have that conversation with them. And as I'm going to make a recommendation, especially now more than ever, any conversation that you're having with a client, if you have it over the phone, follow up with an email. Just say, hey, I wanted to recap our earlier conversation. Let's make sure we have a paper trail. If things happen down the road, you're going to want to have some sort of documentation. We're showing, hey, why did we not have an open house? Well, here's the email showing that we discussed the following items here, as opposed to having to rely on a phone conversation someone may or may not remember. The next thing I want to make a note of is that the governor yesterday in his guidance has instructed law enforcement to essentially break up any organization, any group of 3 or more people that are not relatives and a family. So keep in mind with an open house that you cannot have more than 3 people in the home at a time. So when you go to talk to your seller about, hey, do we want to have an open house? You may want to call and lead with that of, hey, just understand that we really can't do one in the traditional sense because we cannot allow more than 3 persons into our home at the same time. And if you want me there, then we're really down to 2. And then the last thing would be just to say, hey, look at some different options for doing an open house instead of the traditional model. Maybe see if you can do some, virtual tours. Reach out to your brokerage, reach out to your MLS, and see what alternative options are available. Talk to your clients and say, hey, do you want to maybe shoot some video around the house? Do you want to do, a Facebook Live or something, kind of think outside the box and maybe don't go with the traditional model of this is what we've always done. They always say extraordinary times call for extraordinary measures. So let's make sure that we're kind of keeping those in mind going forward. And then I wanted to toss it to Nick for real quick about MLS suspension of open house displays before I get to our next item.
And Austin, I've got a couple of questions here from a couple of brokers. Let's answer those real quick before
Absolutely.
we leave this area. One question from a broker was, can Austin talk a little bit how the law firm is different from a real estate company as it relates to releasing earnest money?
Absolutely. So the main reasoning is you guys are guided by the Real Estate Practice Act, your license law. That license law does not apply to attorneys. So the guidance that the interpretation by the Real Estate Commission of the statute is that you can only disperse funds for mutual agreement of parties or a court order. Since law firms are not and lawyers are not subject to your license law, the rules in your license law do not apply to them. Now lawyers do have their own trust account guidelines that are extensive, but so essentially they have their own set of rules that they have to abide by, but they're not essentially held to the guidelines within your license law.
All right, thank you. I think that also addresses another question we had where we were asked, can you explain when an attorney holds earnest money, how does that affect the contract? I think you just explained that.
Can I add one thing? So the escrow agreement is a separate agreement from the contract. That is not to be stapled to the contract. That is a separate agreement between the law firm, the buyer, and the seller. But you're going to want to have one of these in your file. Because when LOR knocks on your door at some point and says, hey, I want to see the Jones file, and they go, well, hey, I saw there's $1,000 of earnest money. Where is that in your account? Why do we not see that ever showed in your account? You can say, here's the escrow agreement with the law firm showing that money never came into our office, never, the buyer brought it directly to the law firm and the law firm dispersed it pursuant to their agreement.
Okay. And another question, are attorneys normally holding the due diligence separation funds?
So the due diligence, there's a couple ways that you can do due diligence fee. A lot of it depends on how the proximity of your client and also maybe the tech savviness of your client. So the termination fee is only due if you terminate the contract under due diligence. But that fee must be presented to the seller before that 6 p.m. deadline. So if you have a client that's local and you feel like you give them enough time, they can write a check and have that delivered, then you don't need to have that ahead of time. But say if your client is from out of town, doesn't have, is maybe now, especially given, particular quarantine issues, they're at an at-risk population and their mobility is limited. Maybe you do have that money essentially deposited with a law firm, put in that escrow account. So when the buyer decides that they want to terminate, the transition to getting that money to the seller is much quicker.
Okay.
That is a reminder in your due diligence period, you need to make sure that you do every single thing before that 6 p.m. deadline. So that means the buyer does all their inspections, they make all their requests, the seller comes, gets all their estimates, buyer and seller agree to terms, and that termination fee is delivered if need be. At 6:01 on that deadline, you're in an as-is contract in regards to repair. So again, make sure that you give yourself plenty of time to do all these things, understanding that the ability to maybe get inspectors and contractors may be delayed more than usual.
Okay, let's change gears and talk about a couple of questions that have come up. And we have a couple of brokers that have, and I'll address this. So what would you recommend if a seller client discloses that they have been tested for coronavirus with either a positive result or still waiting? We actually, I fielded a call this weekend on this very issue where a seller client was diagnosed positive for the virus, and the selling agent, the listing agent was concerned about what their disclosure responsibilities were. We advised that they get permission from the seller to disclose their status, their medical status. Be very careful about privacy issues here. And they shared that information with the buyer. Fortunately, the only one that had been in the house the past 2 weeks had been a home inspector, and so the home inspector was notified. But for all our realtors that are on the meeting today, know that we're into a lot of new ground here, a lot of new territory, and there aren't necessarily right or wrong answers. Obviously, we want to protect our agents. We want to protect our clients and customers. The more that we can disclose, the better. And it's always better to have permission to disclose. I know we've shared that scenario with NAR Council, and we expect some new guidance from NAR regarding what to do when a buyer or a seller have been diagnosed positive with coronavirus. So one question about the public gathering, Austin, and we've got to move on because we're scheduled only for an hour today. And what I will do, any questions we don't answer live here, we'll make sure we email you directly, okay? But if the governor's order does not apply to business gatherings, right, Austin? This is just public gatherings like on the beach or on the street or anywhere else, right? If there was an open house or folks in an office, how does the 3-person max rule apply?
Yeah, so I mean, obviously, I don't think it was for a business setting. Open house, it may get into that area where that's, especially for, a neighbor that's not aware, it may be hard for them to distinguish, hey, I don't know why there's people coming over to the house. So maybe that's another thing where you, maybe you let the seller lets their next door neighbors know, hey, by the way, we're having an open house today, but kind of, also keeping in line with the CDC guidelines that the CDC has recommended no more than 10. So kind of making sure that you kind of keep, your group small. If you're planning on having more than 3, make sure it's not more than 10, and then go ahead and try to communicate as best as possible, maybe with the neighbors, so they don't think you're just having a house party, that you're actually conducting business.
All right, so just real briefly, my topic under this section has to do with MLS suspension of open house displays. I know many of our brokers have been reading the news and headlines from across the country, and we know of 2 big MLS systems in the country, one in Houston, Texas, and the other one in the state of Washington, have adopted a policy that they're not going to display, you can't search for open houses. They've left it up to the brokerages, the individual firms, to decide whether or not they're going to do open houses at this time. And interestingly enough, I know many of you are invested in virtual tour technologies. It's very, very interesting. I would encourage you to check out your local MLS and see just how many homes have virtual tour options. Certainly may be something you want to consider in your practice if you haven't adopted that. So nothing really to add here other than this is a broker-led decision about whether or not you decide to do open houses, as Austin mentioned. But as far as your MLS is concerned, that is also something that you need to have a voice on if y'all are going to address this issue locally. I'm not aware of any South Carolina MLS that has done this. I know voluntarily the open houses have slowed down quite a bit, but I know they're still being held in some areas. So FYI, stay in touch with your local MLS for these kinds of questions.
Okay.
Austin?
And I'll do my last item real quick before I hand it over to Byron. Just want to let you guys know that the Forms Committee and your President Owen Tyler have created a release task force that is currently looking at the residential lease and the residential management agreement. They had their first meeting last week. They're having their second meeting tomorrow, with the goal of having drafts to the Forms Committee by their April and time for their April meeting, and trying to move those out as soon as possible. That is something that's being worked on at this time, and wanted to keep you guys updated on that. And that's it for me. I'll go ahead and hand it over to Byron for more legal goodies.
Thank you, Austin. Thank you, realtors, for tuning in. If you need to reach us, the hotline is open for business, so you can email Austin at screaltors.org, Byron at screaltors.org, or Nick at screaltors.org. Phone number is 803-772-5206. I want to make one very, very important point. First of all, so listen up. This is very important. This coronavirus emergency, we're going to get through it, but it is not a rent holiday. It is not a rent holiday. So tenants must pay the rent. They must pay the rent. This is not a rent holiday. So despite the fact that, as Austin talked about, the courts taking the coronavirus emergency orders that have slowed the courts down, and evictions have been postponed till at least after May, it is not a rent holiday. So for residential tenants, they need to listen up. It is not a rent holiday, not a rent holiday. So they must pay the rent or they're going to get evicted when this thing clears, and it will clear up. We'll all be okay. We've been through the floods and the hurricanes, the recession. So we'll be okay. We'll get creative just like realtors always do, but it is not a rent holiday. You must pay your rent. And as Nick was talking this morning, if your commercial tenant is a liquor store and they tell you they can't pay the rent, they're probably lying to you because they're making some money during this emergency. So for residential properties, keep in mind public policy is that this is a public health issue. The government does not want people basically homeless. They have to have a place to shelter in place, to isolate if they're sick, to quarantine if they've been exposed. And so keeping people in their properties is important. So this can apply to a realtor if you're renting, can apply to a realtor if you're an investor and you have tenants. It could apply if you're renting office space. It could apply when you're dealing with these tenants. These tenants, some of them are going to have coronavirus issues with their income. So we're going to have to get creative, maybe work with them, try to figure out a way to work out a way with rent. But remind, you're going to have to educate these tenants, just like your local officials, how you do business. That is not a rent holiday. Just because the courts are not taking evictions for about a month and the utilities are not shutting off for failure to pay your power bill or your electric bill, it is not a holiday. Those fees are all still due. So it is not a rent holiday for tenants out there. The other thing that's come up on the hotline are showing properties with tenants in the residence, in the dwelling. So our lease, and Austin talked about the lease updates coming from the the property manager task force. They're updating the lease, but currently the lease allows showings and tenants cannot unreasonably withhold access for showings. And the question is fear of the coronavirus a reasonable reason to resist showings? So we're going to have to get creative. You heard, Nick and Austin and President Owen talking about virtual tours, being creative, working with people, getting on the telephone, trying to work out a solution. So maybe you use videos or use a virtual tour of the dwelling, or you talk to the tenant and try to alleviate their concerns. Let them know that you're asking questions about people's health, that you're not bringing a lot of people through there, that you're trying to clean up after yourselves once you go through the property, that maybe a solution is virtual tours. Maybe a solution to keep the tenant happy is to give them a discount on the rent, try to keep them happy so they comply with these showings. But right now, the courts are shut down pretty much for everything residential real estate. So being able to evict a tenant for not allowing access to the property per the SCR lease agreement is going to be problematic. So try to work with them. So we talked about, on the flip side, Nick received some good news just prior to this call, because we've been getting a lot of calls from realtors that have investment properties and aren't receiving rent. So it's going to impair their ability to maintain the property, pay their taxes, pay their insurance, most importantly, pay mortgage payments. So Lindsay talked about some of the relief payments coming to independent contractors, self-employed. We're also going to see some relief on mortgages and foreclosures on that side for the folks that are paying the mortgage and relying on that rent payment to make those mortgage payments, upkeep the property, pay their taxes and insurance. Any questions so far, Nick?
We've got a few. Broker in charge, Mary Broughton wants to make sure that what you're saying is that it's not a rent holiday. Is that what you're saying?
Yes, it is not a rent holiday, not a rent holiday, not a rent holiday. Just to make sure it's not a rent holiday. Pay your rent. Thanks for that reminder, Mary Broughton. And then summing up, vacation rentals, Nick and Lindsay and Austin, we've been copied on emails from folks down in the Charleston area, especially the Edisto Beach area, the Folly Beach area, the Sullivan's Island, the Isle of Palms, getting some concerning news about impeding the ability to do vacation rentals, how you do your vacation rental business, causeway blockages, checkpoints. Just be aware of vacation rentals. Some of the same issues are going to apply. You're going to have to educate your local officials on, why you need to get on these islands to make sure the property is cleaned up before the tenants and after the tenants, and kind of educate them how important your business is on vacation rentals. So that's some of the reports we've been getting on the hotline. And that sums it back up. It's not a rent holiday.
All right, let me address some of the questions. I know we're trying to cover a lot of information here really quickly. I'm sorry for the fast pace of this. I know it can be a little hard to hear sometimes. So the relief that Byron mentioned, FHFA announced today that they will be providing relief for landlords as long as they're not evicting their tenants. And there'll be some tenant relief as well. So they see the importance of maintaining support not only for the tenant but also for the landlord involved as well. There's a couple of other questions here. I just saw posted on the Post and Courier that Charleston City Council is pushing for a 2-week stay-at-home restriction. So that is some breaking news that I haven't seen in any other county yet. And one of the directors just pointed out that at least one county in North Carolina just issued a kind of a stay-at-home order as well. So we'll monitor that and get the news out to you as soon as it breaks. Another question, Byron, is it up to, so it's up to the management company to decide how and if they want to work out rent payments with tenants, right? How would you answer that question?
We're going to be creative, and we're learning from you all as well. So please give us feedback as solutions that you're finding in the field, because obviously none of us have been through this issue before in the past. Just thinking out loud, if I was trying to work out a solution on, hey, I'm a waiter, I'm a bartender, I've been out of work for since the middle of March. I don't have the rent. I'd love to pay you. I just don't have it. Getting in touch with the landlord, talking to the property manager, talking to the tenant, looking at the news, trying to consider, hey, maybe since the courts are closed anyway, we cut Byron some slack. We let him, we delay the rent. We give him reduced rent that he'll pay back over time. Say my lease runs until December. Maybe we agree to forbear my rent in March and April. And then you add on $150 in June, July, August. But we're going to have to get creative. We're learning from you as much as anybody. So please, please, please contact us. It's just our first name and then at screaltors.org, and our phone number is 803-772-5206. And Austin, Nick, do you have any thoughts if somebody couldn't pay the rent about working it out for the property manager? Would you get the landlord involved, or would you some suggestions, or even you, President Owen?
I mean, I honestly make sure it's the owner's property, make sure the owner's good with it. And again, this is more important. Don't just rely on the phone call. The owner told me it's okay. If the owner tells you over the phone it's okay, get it in writing. Send them an email, summarize the phone call, get them to confirm it. Keep a copy of all that documentation, because that's something that's going to be important. If the seller, if the tenant agrees to something, have them put it in writing. Don't just have them rely on it, because make sure that you're kind of getting everything in writing, that you have all the documentation you need.
Yeah, good point. So call the hotline 803-772-5206. Well, you can update the lease with that. We could help you write that into the lease, and everybody signs it, and you're good to go.
So one broker asked, how do we assist out-of-state landlords with any potential relief? We're not sure yet. Until Congress, until we get the actual language, we get the actual implementation of some of these relief packages that are being adopted, we won't know the exact answer. So stay tuned. Let's get back to the agenda. I know there's quite a few more questions. Let's try to save these for Q&A. What else, Byron, do you have on your list?
I can jump ahead if you want about the mediation, or I can wait, however you want to do it.
No, go ahead and cover the mediation real quick.
Right. So we're trying to give you some good news, right? Because you're just getting bombarded by bad news the last couple of weeks. So help is on the way for the landlords. I thought that was a bit of good news. The other bit of good news with the court shut down is our mediator corps. We have a lot of mediators for South Carolina. And then early this week, I asked them, I said, hey, would any of you be willing to volunteer your time to do video mediations to help us do security deposit disputes, or landlord-tenant disputes, or earnest money, or repair disputes, even during the transaction? Nick and Austin and Owen have all relayed that they've helped people work things out over the phone. So we've been using Google Hangouts and Zoom conferencing, and we had about 20 realtors volunteer to do free, no cost, free mediation. So it is a mediation holiday. It's not a rent holiday, but it is a mediation payment holiday. These mediators can keep you socially distant. They can beam in from a different part of the state, so they don't have any kind of conflicts of interest, and can help mediate any dispute during the transaction, after the transaction, at no cost. Typically, these mediators charge to try to help the parties reach a settlement. Sometimes it's good to have a third party, and what we're also seeing is people don't talk on the phone anymore. So just getting people on the phone can often solve a lot of problems. So we're going to try to give you a bit of good news and a little bit of relief. This is the only operable alternative dispute system in South Carolina with no travel and free at no charge.
Awesome, thank you, Byron. So let me cover a couple of. I know many of you practice commercial real estate. The focus that Congress has had in the last week is a lot of it has been on landlord-tenant residential real estate issues. And I wanted to briefly touch on a couple of commercial items that NAR is working on. And I'll be real brief. We'll email these documents. You should have already received them in your weekly update, but there's a deadline extension that NAR is proposing and urging Congress to adopt regarding 1031 like-kind exchanges that are due to the coronavirus crisis. We've got a copy of that of a letter that NAR has sent to Congress with some additional details that we can share with you. NAR is also urging Congress to extend the deadline for qualified opportunity funds, working capital, safe harbor periods. This is in response to delays, again, that are resulting from the current crisis. And as part of a coalition, we mentioned the efforts to provide commercial landlords with some relief as well, as tenants, businesses are being undermined again by these shutdown orders that are occurring all across the country. So those are just a couple of commercial issues. As Lindsay mentioned, we're going to get a lot more updates, I think, in the next 24 hours regarding what Congress is doing. And we'll be providing that to you. So please check your email. Please share it with your agents as well. So Owen, I was going to jump into the remaining questions. Was there anything else that you wanted to cover before we did that?
No, I don't think so. I think it's just really important that we maintain an open communication line with our agents and with our clients and our customers. So much of this is emotion driven. So much of the I want out of the contract or what are my rights, I really believe has a lot to do with emotion. And if we can calm everybody down, give everybody a moment to breathe, I think we can actually make some headway in the transactions. Some of the transactions may not work, others may work, but we at least need to give it a chance for our businesses and our agents and frankly our clients.
So
I'm sorry, Nick. I was just going to say, as we've been on this call, a lot of you are texting about other things that are kind of happening with school closures and that. As these things, it's a fluid situation, and so as things develop, we'll continue to send emails out from SCR with updates. Stay focused on the emails from your local associations. I think most people are kind of basically local associations and SCR are pretty much sending only issues related to this that you need to know about. So keep posted on that. Some of the stuff we say right now may change in the next couple of days. And so I think that's an important thing to remember, that always refer back to those pages. And I believe all associations, local and state, have pages set up and they're updating those pages as stuff changes.
On behalf of your SCR staff, thank you for your leadership in your communities, and thank you for all that you're doing to help keep our business moving forward. And with that, Owen, I'll let you turn it over to you to close it out.
Wonderful. Well, I just again thank everyone for dialing in today, taking the time. I know I can speak for the staff at SCR who've been working very hard, your local associations. This is something that we're all nervous about. None of us know what the outcome will be or the answer will be. I think we have to stay on a positive note, and we have to be out there continuing to do business for as long as we can. And I think that a lot of the agents, those that don't own companies and aren't broker in charges, are very concerned about the closing they had last week might be the last closing they have for a while. And I think that we need to spend a lot of time with a lot of reassurance, not only to our clients, but to our agents as well. So thank you everyone for being here, and on that we'll conclude.
Thank you everyone for participating in this historic event today. Have a great afternoon.